All right. So like we said, we're going to talk about TPOPP and OHDNR orders and other OHDNR forms in the states of Kansas and Missouri, and sort of do a little bit of a compare and contrast, showing kind of where they're grounded in the law and how they function in the clinic, and so on. So we can go ahead and get started. I guess, do you want to go ahead and take this? Yeah.
Yeah, so the Center for Practical Bioethics has been around since '84. We're a freestanding, independent, community-based organization, probably one of the only two in the United States for bioethics. My background is in hospice and palliative care, so I assume most of you who work in the field will have some affinity for some of the remarks that I make. The center, as an independent organization, is operating the Missouri and Kansas TPOPP program, which stands for Transportable Physician Orders for Patient Preferences. We do that as a community benefit program and receive no compensation other than through grants. And currently, I don't think we have any current grants that are operating. We also develop materials and resources that are sold to cover costs. So we don't really benefit from that, other than the fact that we have to be able to replenish our supply and our collateral materials in order for us to be able to move forward. We'll cover an overview today and talk about when is TPOPP and when is POLST appropriate. And we'll talk about those being one and the same thing. And then kind of the history of this in both the states of Kansas and Missouri, starting off in the regional effort that we did in Kansas City. And we'll also be giving you a little bit of a picture on national trends within POLST generally, and specifically within the efforts that we have in both Kansas and Missouri, and talk a little bit about that. And do we need to talk about those here, or the trends, or do we have that later on?
We just have some trends kind of listed here. They're not broken out very much in the presentation. Okay. So if we've got anything that we want to update on, we should just do it now.
Yeah. So those of you that may have some history with POLST may know that it stands for Physician's Orders for Life-Sustaining Treatment. It started in Oregon 20 years ago or so. Anyway, there was an effort to kind of try to figure out how do we know for sure that somebody could benefit from a POLST, and they originally did some research in the area of the surprise question, which was around, would you be surprised if the patient died within the next 12 months? With a very different question than would you be surprised if the patient were alive? And they had that, and that's what we used for a while to determine whether or not POLST forms and the process should be pursued with the patient or client. That has kind of fallen away because of additional research that's been done, and we'll cover kind of some of what that is. There's also been a lot of resistance among some sectors, especially in the life protection groups, around what POLST might mean in accelerating basically a patient or hastening a patient's death. So there have been some concerns related to that, and the center again has been pretty active in working with the National Catholic Bioethics Center in helping kind of facilitate some of the concerns that they've had related to the POLST documentation. And I think we've made pretty good progress there. There's a lot of open dialogue now around that topic. And then local initiatives, we'll talk a little bit about kind of where the community coalitions are within Kansas and Missouri. And then really for the purpose of this webinar is to really dive deep into the purple form in the state of Missouri and the out-of-hospital Do Not Resuscitate directive in Kansas as a result of kind of some confusion and some initiatives that sometimes confound the two and conflate the two, and we need to be separating those issues for you guys, especially for your benefit in working with patients and families. And then we'll also talk a little bit about some of the form changes and the updates in the literature. Okay, I'd like to kind of underscore this whole need, and you guys in the social work arena, in social services, really understand the importance of not treating this simply as a form, but really using the discussion of advanced directives and being able to kind of tease out goals, preferences, and values from patients and families related to the course of their illness or their conditions and what it might look like in the future, in order to really begin to engage them, the patient and the family, certainly the patient if they have capacity, and the family if the patient doesn't, and even in some cases where it's maybe transitioning, and those conversations obviously are very important. And so the potentially life-prolonging treatments in some cases are contraindicated in advanced illness cases and may be potentially risky in others, and we need to do a better job of making sure that patients and families understand those risks and the potential benefits and have an open discussion about the course of care and the goals of care that would then be implemented in the treatment plan. So the other important area is that advanced care planning really informs what the medical order set will be and the goals of care. So when you institute a care plan, obviously there are medical orders that accompany that, and it's really important that in advance of that we really have a thorough discussion around how advanced care planning informs that discussion. And the general problem we have with advanced care planning in toto is that very few people complete them, and if they do, they're not saved properly, retrieved, stored, that kind of stuff. So we obviously have historical problems with that. So traditional advanced care planning is really focused on the appointment of an agent and then the healthcare directive. So that's usually two sides of the same document. As on one side you name an agent, and on the other side you basically state your preferences, usually in the healthcare directive, around the kinds of treatments that you would or would not want. That side of the document is less important than obviously the first part, and everybody who's an adult needs to be able to name an agent and then have a conversation. The advanced care planning is obviously future oriented. It is not it's not focused on the immediate needs right now, usually, and it's educational and reflective. It provides an opportunity for discussion and hopefully engages the family around the kinds of things that are important, the values that the patient has, and then how those then get translated in conversation and then informing of the agents and the family members beyond the agent, and provide some guidance and direction to those people, including healthcare givers and folks like you who advocate for patients when it comes to the point of trying to make decisions. So there's 2 points to that: the appointment of the agent and then the healthcare directive. And it's something that everybody should obviously do. And the other final point is that there is, in completing an advanced directive and in completing a healthcare directive, there is no requirement that a healthcare professional be involved. And that is not true with the medical order set. You must have a professional caregiver, a provider involved. So what is TPOPP? TPOPP is Transportable Physician Orders for Patient Preferences. It is a POLST program and specific to Kansas and Missouri. So we've done a lot of work with the National POLST office on making sure that the important elements, there are 9 required elements and sections that are required for any POLST document to be in line with the National POLST paradigm requirements. And we've done that, but we've initiated some Kansas and Missouri specific things, which are now in some cases being adopted across the country. So the POLST form, the TPOPP form, really covers 3 different areas: cardiopulmonary resuscitation, limited or additional interventions that the patient and the family choose to do along with their provider in defining what kinds of treatments are appropriate or beneficial. And then finally, the question around medically administered nutrition. And this is limited to nutrition, not hydration. It is simply the medical administration, the clinical administration of nutrition. And then the whole idea here is that this is supposed to follow the patient wherever they go. And so it's in the nursing home, in the community-based setting, in the hospital, and it also is a dynamic document that may change over time.
Which is why it's a uniform form.
That's right. So we need to make...
The form itself can go with the patient.
Okay. So the difference between advanced directives and POLST, and I know I'm accelerating this part of the presentation. I'm assuming most of you have been working in this arena for a long time. But just so as you talk to other people about it, we really would encourage you and request that you make a clear distinction that an advanced directive and the living will, both the appointment of the agent and a living will, is really initiated by an adult individual who's met majority age, and it has to be executed and initiated by that individual. It is completed with the anticipation that it will be put into place in a future state. It becomes effective when decision-making is no longer able to be exercised by the declarant, but the person who's executed this document. And it may not be available in all settings because in the past it's been a paper document that we've relied on. A POLST document, a TPOPP document, on the other hand, is informed by everything on the left, but it is actually initiated and executed by a healthcare professional, a licensed healthcare professional, and in the state of Kansas and Missouri. Right now that is limited to PAs and doctors in Kansas and to, in Kansas, and then physicians in the state of Missouri. Both states are working on allowing nurse practitioners to participate in that based on scope of practice or collaborative practice agreements. We will keep you posted as that changes, but right now it's physicians in Missouri and physicians and PAs in Kansas. And they can execute the document based on the information they have around the preferences and values of the patient for the medical orders that are set in place by the providing team. So keep in mind that this is a big distinction, and we need for everybody to understand that medical orders are POLST and TPOPP. Advanced directives are initiated by an individual, and that's a patient-driven activity, and one informs the other. So medical orders are now, they're in place for the current rather than necessarily the future, and they need to be reviewed and changed as necessary going forward. And it is not dependent upon decisional capacity of the individual, all right? That's already been determined with the conversations either with the declarant himself and herself or with the family agent representative. And then this whole idea is that it's supposed to, go across settings.
We have a question right here, is that can the social worker initiate the conversation in hospice and have the physician sign it, especially when a patient is not able to sign a DNR?
Okay, this is for I'm assuming an order, not
this is for like the serious illness care planning conversation that you would have that would result in TPOPP.
Right. So, and I don't know if we'll get into the form itself, but
not very deeply.
Okay. So the POLST form in most every state, I think there are a couple of exceptions, has a second signature. It's a medical order, and a medical order is not witnessed by anybody. It shouldn't be, because it's a medical order. It doesn't need to be. It's protected by the license of the individual and by the scope of practice and the standard of care. So it's a medical order, it's freestanding. However, in the POLST initiative around the country, there is usually a requirement that there be a second signature on the form, either from the patient or the representative, indicating that this is in accordance with the goals or the understood goals of the patient. So there is no limit on who can initiate that conversation. A family can initiate that conversation. So a social worker could facilitate the conversation and begin the process of introducing the family to the medical order. And the physician then could confer with the social worker and the family. This is what has been given to me. This is what I understand. I want to make sure that you guys are on board with this. And so now we're going to talk about what kinds of things we will complete on this form that are indicated by the goals and values that you have. So the social worker can certainly engage the family and the patient in this process and prepare information for the physician, but the completion of the form really should be, the execution of the form, the signature on the form needs to be in the hand of the provider with a license who's authorized to sign. Okay, this is just an image. This is just kind of a picture of where in the process does POLST really hit. Advanced care planning, all those things we talked about naming an agent and filling out kind of the preferences and values, and on the left side of the screen, anybody over the 18, whether you're healthy or not, needs to be doing it. On the right side of the screen, you'll see where once you've been diagnosed with a serious illness, that's when the POLST document, the TPOPP document discussions really need to begin. And that's why we call it serious illness care planning discussions, is because those kinds of conversations do involve a clinician and are much more serious and related to the specific kinds of treatments that will reflect the goals and values of the patient. All right, this is another picture. The only reason I bring this up is that most of us see ourselves as dying in that the preferred way to die would be in the upper left-hand corner. You go to sleep, you have a massive heart attack and die, and that's the way we'd all like to go. Doesn't necessarily fit with the person sleeping in bed next to you, but it's kind of how the preferred way that we say we want to die. What happens to most of us, more than 50% of the cases, are in those bottom two trajectories. The trajectory 3 is really related to progressive heart, lung diseases, and in some cases neurological diseases, and in section 4, in the fourth box, is really the long trajectory of the advanced multiple chronic diseases, and sometimes what we know happens most is with advanced neurological diseases that take a long time to impact the patient's actual mortality. This is just a quick way of saying, so how do we know for sure that there's a select group of people who would benefit from a POLST conversation? You guys live it every day, so I know you know, but there are now pretty good evidence that diagnosis, functional impairment, and high utilization of services is really the way for us to detect this. So we don't need the surprise question anymore. This is the literature, the body of literature that has really led us to believe that we can engage people around the conversations, around having the POLST discussion once we know these are in play, the diagnosis, the multiple diagnoses, the functional impairment. So most of these are already in place for those that are living in long-term care settings, and so usually that population is identified pretty readily as needing the POLST conversation. This is just a picture of where POLST is around the country. The really, really dark, or red, I guess it is, are states where it's what's called mature. We're going to change that wording pretty soon. It's more around that those states are already collecting data in terms of concordance with goals and the execution of the documents and how many are being executed and that kind of thing. The lighter pink, it's still rose-colored, on there are the states that are already involved in statewide initiatives, prepared and executing documents, and have resources available through one statewide agency, which is what we do.
So have been endorsed at the national level.
And that, yes, and that we've gone through a process being reviewed by the national organization that all the 9 components are in play, and we're doing a good job of it. Yep. So you'll see that. So we brought Kansas and Missouri, the POLST initiative in 2009. It's been around, so it's been around a decade now. It started off in Topeka. We now have a bi-state coalition that was formed in 2012. Had a lot of uptake in eastern Missouri this last year. Probably the only places in Kansas that were a little bit shy are still in the western parts of the state, and we'll be asking for some support this year to basically extend it to the more rural areas. So we were endorsed, as Matthew just mentioned, by the POLST National Office in 2016, and we'll be up, I think, for renewal in 2022 or something like that. Here's a quick map of kind of where we are in the communities. We use a community-based approach. We do not seek a legislative remedy and will not seek a legislative remedy, and the reason for that is we want to make sure that the uptake is genuine, that it is widespread, and that we've got everybody working together, long-term care, hospitals, home health and hospices, and EMS. They're all working together on this. So you'll see a huge bundle up there in the Kansas City region, but we do have programs in western Kansas. We do have them in the Wichita area, a number of the institutions, southeast Kansas, and then the providers on the eastern side in Missouri. Most of those are community coalitions as opposed to individual institutions, but we do have all the way down to the Boot Hill. St. Louis has really kind of exploded this last year, and some significant uptake, especially in the middle part of the state at Rolla, and then in the lower southeast quadrant, the lower southwest part of Missouri, excuse me, in Springfield and the Joplin area. So why standard of care? Because clinical consensus is important for us in being able to make sure that across settings we know what's going on and that people are talking to each other, listening to each other, and responding to the needs of the patient. We believe that the non-legislative route provides us more flexibility and sustainability That's been particularly important. We've changed our form how many times?
2 or 3 times.
Yeah, 2 or 3 times in the last 4 years or so.
Yeah.
And most states run into trouble when they initiate a state law because they don't have the flexibility in being able to change the document based on standards that may be changing, especially within the palliative care field. So there are about 19 states that share the standard of care approach, as does Kansas and Missouri. We still, though, need support from key regulatory entities, EMS, departments of health, aging, those kind of things, and that's what the center does in coordinating with our statewide bodies. So we've got, you know, the state boards of EMS that we work with. We've got the long-term care associations in both states, and we try to make sure that they're involved in what's going on, and then obviously with the hospital associations, working with them.
We've got a question that I'll answer real quick. Just says, we're in a hospice in Wichita, and have not seen this in utilization in Wichita at all. Uptake kind of happens in a sort of patchwork fashion. So there's places in Wichita where it is, or institutions that are using it regularly, and others that are still onboarding. If you're interested in getting put in touch, and this goes for anyone, not just Wichita, if you're interested in getting put in touch with people who are implementing and using TPOPP, you can write me at tpop@practicalbioethics.org, and that contact information will be at the end of the presentation as well.
They do have an active leadership group.
That's right.
They're meeting this week. They are active in the Via Christi and in HCA. I don't know that VA has been very involved with them, and they've been active for 6 or 7 years. So there is an active group and really a citywide, region-wide coalition. They're active in Butler County, Reno, Sedgwick, I think Sumner, Cali, in that region. So they've been active for quite some time.
Yep. So if you just reach out at that email address, I can put you in touch with those people and get you on the road to implementation.
Okay, so all of you, particularly social workers, know that this is a process and not necessarily just a form, though the form is very important, especially as we move ahead and it goes across settings. So it requires serious engagement with the patient and the family and the representative in understanding the values of the patient and translating those preferences and values into a medical order set. That's really what this is about. So you go from a patient-initiated, directed activity to a clinical activity that reflects those values and preferences so that we provide the kind of care that the patient is saying they want and need, and not providing rescue attempts at medicine that cannot benefit the patient or pose additional risk to the patient in terms of their health status. We have a clinical guide that goes with this. This document is available for download. It's a lot, so we also sell the document for enough to cover our costs if you're interested in receiving it. It covers a variety of things, including kind of guide to the clinician. Somebody asked earlier, can a social worker be involved in this? Kind of guides the clinician in terms of the preliminary discussions that are engaged in as the conversation begins. It also underscores a lot of clinical reference for research that's been done in the last 10 to 15 years. We've updated it from 2014, I think, to 2019. It has a form in it so that you can obviously discuss that. And then also it has significant references to training for clinicians in how to have these conversations based on free services that are provided by Ariadne Labs and the Brigham and Women's Hospital in Boston area, along with MIT, the School of Medicine at Harvard. There's also some cosmetic changes that we made to the document, and that's pretty new. I think it's 18, 20 pages long, something like that. You can order it online. No, you can't order it online.
We don't
have to order it through Matthew.
Yeah, you'd have to order it through me at that email address. But just to reiterate, you can just download it as a PDF for free. So if you want to review it, you can do that.
And there's the email address that Matthew mentioned earlier. And we'll get you these guys. We'll get you guys the slides so that you've got these and that. All right. So the coalition here in Kansas City started, as I mentioned, in 2009. In this region of the state, we've got pretty good activity. We've got 22 major hospitals. So it's a big project for us. Not everybody's on board yet. I will say, those of you that, and maybe this is true, in Wichita, we had a conversation yesterday with Susan Fry, who is in charge of kind of the long-term care support for activities in Wichita area. and she mentioned that the biggest challenges they have are in long-term care, and that's nationwide. So the problem is the tremendous amount of turnover that occurs in long-term care settings makes it difficult for them to really embrace this in any kind of meaningful way. But we're working on it. We've got some training programs that are going to specifically focus on long-term care with the DNP at KU that's working on it. There's also some resources that will be coming out of Indiana that we hope to be able to share nationwide in the course of the next 6 months on training on site for long-term care professionals. Okay, this is a big slide, and we have this form in handout form.
Yeah.
So,
just to be clear, so this is a table that is a comparison of kind of the TPOPP medical order set to the Kansas DNR directive, and we'll kind of walk through the content of this comparison. But the we have this as an actual table that we can make available to you all. So don't feel like you got to like frantically screenshot these slides so that you have access to it.
This is a handout that we will provide you, and I think Emily has it, right?
I believe I sent it over, but I'll resend it.
So we'll resend it to everybody that's on the call. So this is kind of really, I think, what Emily would ask that we talk about with you guys. So we're going to spend some time going through this. So let me just give you a brief history on the Kansas Do Not Resuscitate Directive. Okay. In 1990, there was a major initiative. This was following the Cruzan case. Those of you that are old enough to remember may remember Nancy Cruzan that went to the Supreme Court. And there was a movement that followed the decision, the Supreme Court decision, for consumers to basically be able to say when they do and do not want to be resuscitated going forward. Because Nancy had, and it includes the medical administration of nutrition. So it's kind of this. She was kept alive for 9 years. The family's request for her to be able to not be on a ventilator, which they did take off, and she survived, and then to have her nutrition basically terminated after there was good evidence that no amount of intervention was going to assist with her, and she was declared basically kind of brain dead at that time. So it was a long period. So Kansas advocates, people, consumers actually presented to the legislature an initiative that allowed them to be able to declare when they did not want to have a DNR on their own. They did not have to be in a terminal condition. They simply got the law passed. Immunity was provided to any physician or EMS provider, allowing them to honor the request of that individual to have a Do Not Resuscitate order initiated because a directive by that individual had been issued to the physician. And so the immunity protection was afforded. And if there was also a provision that allowed for the individual to say if for religious reasons that they were requesting this medical order from the doctor, they did not even to need a physician's signature, that it would be honored in law. So this is clearly, I just want to make sure everybody understands, the OHDNR, the out-of-hospital Do Not Resuscitate in Kansas, is a directive. It is initiated by a patient, requested by a patient of their doctor, and their doctor signs it saying that I understand that the patient has requested this. This can only be executed by a declarant, somebody who has capacity. This cannot be signed, this document cannot be signed by anyone other than a declarant with capacity. So you do not have an out-of-hospital Do Not Resuscitate law in Kansas that allows for anyone to sign the document on behalf of an individual. And we know that's happening all over the state. So it is prohibited, that it does not exist. So let's go through the form itself at the top. So there's a statute related to this law. I'm going to stay on that left-hand column going down, all right? The target groups are capacitated adults who wish to refuse CPR for personal reasons, not just health reasons or religious reasons. There is no illness criteria required for the execution of this document. It is only recognized, supposedly, in hospitals to nursing homes and back. That's where the limitations of this particular form are referenced. It is initiated by a declarant and only by a declarant, a patient with capacity. It is not required, the health status of the patient is not required for the declaration to take effect. The requirements to execute and validate it include the capacitated patient's signature or an immediate instruction from a proxy to sign on behalf of the individual that has to be in the same time frame. It cannot be done at some later date. When the patient initiates it, they say, I can't sign the form physically, sign this for me, so it has to be done at the same time that the initiation occurs. And then an authorized provider signature is required unless as I mentioned earlier, if there's a religious purpose. Part of that reason for that being built into the law is at the time in the early 90s, believe it or not, there were a number of, they weren't itinerant, they were basically traveling ministers, especially in the southern part of the state, who believed in the healing power that they had in handling snakes and other and venomous snakes. And those protections, which were related to religious exemptions, were afforded them to be built into the law. Okay, so that's why there's this religious exemption. One of the reasons there's the religious exemption. There's also others that may be honored. Okay, so adherence to the form. This form has to be, when it's executed, has to be substantially in the form prescribed by statute. So it is limited to that appearance. There are immunity protections based on the fact that you don't have any medical determination really being made by the doctor. They're just simply complying. When the doctor signs the form saying, yes, there's a do not resuscitate order, the doctor does have to sign it, but this is basically to respond to the request of the individual requesting that I do this. And because of that, then there's immunity. And the directive law is not applicable to anybody that does not have capacity, all right? So it cannot be initiated. It can apply to people who earlier had executed one when they had capacity, but it cannot be initiated when capacity is no longer evident. All right, and then on the right side is where you're going to get the POLST form, the TPOPP form. So it is governed by scope of practice, standard of care, and community census. So that's why it's so important to make sure all the players are involved. Long-term care, EMS, hospitals, everybody, doctors. All right, the target group is only for those persons who have serious illness, all right? An advanced illness or frailty. That's the target population. It is not initiated for individuals outside of that arena.
And with or without capacity.
Right, and they can have capacity and they can also be represented by someone without capacity. So this is the standard of care form, not a statutory form, but a standard of care form that has been agreed upon by multiple communities across the state with multiple providers across the state, that this is the form we're going to use, and we're going to change it as the standards change within palliative care or other places as we go forward. But this represents the needs of individuals, especially those who do not have capacity, who have not declared prior that they want a DNR. All right, it's available for all outside the hospital settings, home, community-based, individuals dwelling in the community or residential long-term care facilities. It's initiated by a physician. This is basically maybe requested by a family, there may be involvement there, but it is actually executed by the physician. You guys, as part of physician extenders, nurse practitioners, others, folks who are assisting in the care of the patient can begin the process, but it actually is executed by a physician, or in the state of Kansas, also a PA can do this. And we're anticipating nurse practitioners who are in independent practice would be able to do that as well in the coming months and years. All right, again, it's for health status of the patient, they have to be living with serious illness or advanced frailty. The requirements are that the physician sign the form as a medical order, and that there is a concurrence or a validation to be acknowledging that it is consistent with the patient's goals. That's what the second signature is for, either by the patient or by the representative of the patient. But it is not a witnessing. It is not, you're not witnessing the form when you sign it for your mother who doesn't have capacity. This is basically saying, yes, doctor, this is consistent with what I know to believe. So there's this evidence on the form itself that this was not a unilateral decision by the doctor. It was done in concurrence with the patient or the family, all right? But get the notion of it's a witnessing out of your head, because other documents like the OHDNR directive are witnessed, but this one is not. And then the form is adopted by consensus to accommodate the transportability issues. There is no immunity because it's governed by standard of care based on the doctor's practice and license. And then it is applicable to people without capacity, and also for populations that basically have been, by overwhelming evidence, demonstrated that a rescue attempt may in fact harm them more than it would help them if we were to conduct chest compressions or things like that. Okay, so in Kansas, in 2014, there was a request, there was a concern raised by a number of people that the POLST document, the TPOPP document, did not comport with the the OHDNR directive law, and so then it was therefore considered to be illegal, I guess, or invalid. And so the Attorney General responded to the opinion and basically asked, the question, and the opinion was that clarified that TPOPP is not a directive, and we don't want it to be a directive, it is a medical order, that the DNR directives require a particular form in state statute because it is initiated by a patient, and that is not required. And the opinion was very clear that a medical order is not defined by statute in virtually any situation. And so the AG opinion states a DNR order, medical order, is not required by Kansas law to be any particular form. So that, for us, clarified that this order, medical order, was in a sense still valid. Yes, it did not comport with the OHDNR directive because it's not a directive. And so that was the position that we've proceeded with. And we have been, that's for the uptake. I'm not saying that didn't create some confusion here, but we've been able to begin to work it. So if you've got questions on this, or people are saying, well, I know this is illegal, it's not illegal, it's not invalid. Right, and we've got major hospitals, I mean, in Topeka and Kansas City and Wichita and other places that have done it. All right, I'm going to kind of briefly cover this for the state of Missouri, because some of you may also be in this part of the state and seeing that form on the Missouri side. Missouri actually has an OHDNR law, okay? So theirs is not a directive, and this is basically a medical order. The outside the hospital do not resuscitate is a medical order. It is not a directive. And it is basically also in statutory form and provides immunity. The situation with the purple form is that it only addresses resuscitation. It does not address any other additional interventions or medical interventions that are necessary for the patient in terms of we would want this, but we don't want that, or we want you to, and then it does not address the issue of the medical administration of nutrition, as does the TPOPP form. So we've kind of had the same challenge there, is that people thinking that the only way that you can have a medical order outside the hospital in the state of Missouri is to use the purple form. There is a substantive argument that immunity, which is provided on the purple form, is not transferable to the TPOPP POLST form because it is also a medical order, and that is true. But we're also stating that it's within we need to change this form as time changes, and there's other considerations that need to be on the form, and so we've just simply said this is a companion form. And so the issue around can the TPOPP form still be recognized as a legitimate form in addition to the purple form, the answer to that has been yes. And I think we have the documentation for that. So, and in terms of examples,
yeah, we can.
So let's just go there. So in 2018, we received confirmation from EMS Bureau, the Medical Bureau in the state of Missouri, that indeed the creation of the purple form did not mandate its use, nor did it delegitimize any other legally executed form, the law in no way mandates the use of this particular form, and other provisions in statutes that require EMS protocols does not mandate use of form. So what we did with Missouri was we simply went to them and said, can you please clarify that yes, people can have the purple form and they can do it if they want to deal just with resuscitation, but it does not mandate its use or declare anything else illegal, and they concurred. And in 2010, from the long-term care bulletin, we got the same answers, you know, almost a decade earlier, saying that there's no requirement that the purple form has to be followed. So, and it basically, they even responded to the question about if there is something else, can we use it? And the answer to that was yes, as long as it's properly executed. So any physician-signed DNR is acceptable for regulatory compliance and should be honored. So that's also true in the state of Missouri. So let's go back up. So we have this same kind of handout for all of you if you have patients in Missouri that we've done for the Kansas side. It's obviously different because the Missouri handout actually is about the Missouri OHDNR law, which is a medical order. So the only real difference here in the two is that one deals with the immunity issue in a very different way by the fact that there's statutory protections, and on the POLST side, it has additional interventions in that section B, those of you that are familiar with the form, and it also has medical nutrition as part of the consideration going forward, and also is governed by the standard of care, and kind of differentiates the needs that those patients have, basically a better model, if you will, in terms of the considerations for a family and a care team around the goals of care of a patient, and making sure that we don't insert a feeding tube when we shouldn't do that based on the fragileness and condition of the patient. And it's all part of a adoption of a care plan, like a hospice care plan. So it's a little bit cleaner by the fact that we're comparing law with standard of care, but it's basically the same kind of comparison.
Mm-hmm. Is there anything we want to cover specifically?
Yeah, I don't think so. I don't think there's really anything else. If there's anybody on this call that we need to do this more for Missouri,
yeah,
I'm going to go with that. I'm kind of reflecting on Emily's concerns around the Kansas one. The Kansas one is a lot more complicated, and I know there's been a lot of considerations over time about that. All right, so we're open to questions and
about 15
discussion.
minutes
Yeah,
here.
we got a little bit of time here. I want to go back and make sure that clarity is there for you guys related to, especially on the Kansas side, the difference between an OHDNR directive and the medical order.
And just to review for anyone who has or who signed on after the initial introduction, there's a Q&A function and a chat function, and I'm paying attention to both of them. So if you want to submit any questions for discussion to either of those, we're keeping an eye on them and can answer those questions.
Yeah, and Emily, I saw you were on, and I don't know if you can activate your Q&A. Have we covered?
We might be able to promote her. Let's see if we can.
Yeah.
Emily, I'm going to try and promote you to a panelist and see if we can get your voice on.
I want to make sure that we're covering the request. So we're gonna unmute you so you can speak if you want to do that. Just in terms of, did we cover what kind of was the burning issue for you?
Yeah. Can you hear me?
Yep,
yes,
we can.
Yes, we can. Go ahead.
Awesome.
And they should be able to hear you as well. So go ahead.
Okay. Yeah, I think that was very helpful. I know it answered a lot of questions that I had, and I think that other coworkers had as well. So hopefully this will be really good information for a lot of my team members in all of our offices. And I will definitely post the webinar up to all of our users so that the ones who were unable to make it on today can look at it for reference in the future.
And can you tell us how many of your members or the folks that are on today are working in long-term care facilities? Are most of them, or is this mostly other kind of residential and
well, we're a home health care and hospice company. So we have people in home health care and hospice and private care. So we go into every type of situation you can think of. We're in homes, we're in facilities, kind of all over the place. So I think this helps us to figure out what we can use where and to help educate in those facilities and outside the facilities as well.
Okay. Also, we understand that there may be a lot of questions around conservatorship and guardianship that go along with this, especially for individuals who may need these kind of documents initiated and do not have capacity and haven't named anybody to be. So we've got the issue around surrogacy, and in both Kansas and Missouri, those are different. Also, the accessibility to guardianship and conservatorship in the two states is quite different. So I think maybe if those questions come up, maybe Emily, you or others might be able to help us kind of corral the group that would be interested in a presentation on the Kansas side versus the Missouri side, or maybe
Sure.
those that work in both would want to attend both. But they're quite different. The accessibility to, you know, a public administrator on the state of Missouri is very, very different than how hard it is to get a guardian on the Kansas side. But I think there is a question around an incapacitated person who has not named a DPOA. How do you get out of hospital, do not resuscitate order in place? And I will just say this, in state law, on both sides, there are limits to what physicians can do without going to get an order, an agreement from the court related to this. So both Kansas and Missouri, that you cannot have a physician unilaterally make an order for an individual who is unrepresented, who has not had any declaration prior to, without having made some attempt to seek concurrence from the courts related to the ability to initiate and put into place an out-of-hospital do not resuscitate order. That usually doesn't, in most cases, impede that individual from being represented to elect a care plan or a hospice election in most cases. And in those situations, a care plan may indicate that rescue medicine is not in line with the goals of the care of the patient. That may be true, but you probably would be limited only to that. You would not be able to institute a medical order indicating a do not resuscitate unless there was an effort to pursue the authority by the court to grant that order to be put into place. So it does complicate all of your lives, I know, especially for those of you that are dealing with very frail people who could not survive an attempt at resuscitation. We understand the complexity of that, but there are laws that are in place that say, yeah, that's okay, if that happens, then you need to go to court and you need to get a court order to allow you to be able to do it, or at least present the case to the courts to be able to do it and get a guardian who then can do that for you, or conservator. So we can cover that. We really need somebody, a legal person, to be on that call. I don't have that background, and somebody who deals with elder law and that kind of stuff, and guardianship, conservatorship to really be more informed in terms of how that discussion should be shared with you guys.
Yep, we've got another question here. It says, the TPOPP refers to a recognized decision maker's signature. I assume this means this must be the patient's DPOA or next of kin to be legal. Is this correct, or guardian?
Okay, so the concurrence, we do not stipulate that the concurrence has to take place, because we don't know if there already has been discussion by the patient when they had capacity to be able to do this. So if the individual who has never indicated prior to this point about their wishes or values related to this, has not had what you call in the state of Missouri, clear and convincing evidence discussion taking place, and has not named an individual, then the representative signing for the individual is simply representing that, yes, this is a reflection of that. If the limitations are imposed that we just talked about related to the requirements of the physician to seek approval by the courts, then that path has to be followed. So the form, we don't want the form to constrict any individual from being able to represent the patient however they are. So on the form itself, it says, who are you that when you sign this? Are you the guardian? Are you the agent? Are you the patient's representative? And making sure that it's consistent, because there may be other documentation that allows you to be able to say, the patient can't sign. There's an advance directive somewhere else that says, in fact, the patient doesn't want to be resuscitated. So yes, I'm going to sign this on behalf of the patient because the patient can't sign. So we don't want to impede that process because the individual can't sign. However, if the other circumstances exist in which somebody is signing the form and it's the first time that there's ever been any kind of discussion related to this, then the doctor and the representative are required by state law to follow state law. I don't intend for that to be a dance, and it may sound like one, but we did not want to have the document limit the individual's ability to sign, but the physician is under, and the representative, in terms of if this person has never had any history in expressing their views and attitudes or concerns around this, there is a requirement that an out-of-hospital do not resuscitate medical order must be identified by the individual, him or herself, as a request that they make, or a legally appointed agent if it doesn't exist prior to. If that doesn't, so that, I hope that's helpful. Does that make sense? Did what I say make sense? Emily, did that make sense?
Yes.
Okay. So that's the reason that the language says recognized decision maker. That person has to be able to do it. So, and this has come up a lot with hospice patients where the patient is so incapacitated they can't sign. Everybody knows the patient has said before, yes, this is what I want. I've adopted the care plan. I elected the hospice benefit. I do not want to be resuscitated, but they didn't sign a form that said, but they've given an instruction. An instruction directly from a patient to a doctor or clinician or whatever is sufficient for them to be able to say that that's the evidence, the clear and convincing evidence that needs to be represented.
All right, we've got a couple minutes left. If anyone else has any other questions.
Oh, I want to clarify one point. So a guardian who was appointed, and this was not discussed, there's a guardian representing the patient and a doctor, and this issue around the medical order has not been discussed prior to. Both the guardian and the doctor have an obligation to pursue the approval for signing of the order, okay? So just because you're a guardian doesn't mean you get to sign unless there is an instruction to you already in existence, a advanced care planning document that says, yes, this is what I want, then the guardian represents the wishes of the patient. If it's unknown, then that's when the path to the courts has to be followed. Okay.
All right. Well,
Emily, if you get feedback from anybody in terms of confusion or things that we didn't clarify, we definitely want to know. Okay. Matthew will make all of this available, including the handouts, which are not part of the slide itself. So they're separate documents that we'll send to you guys and you can share. The clinical guide is available online. Multiple resources are available on our website for training and that kind of stuff, and you can do that if you're interested in finding out if there's a community coalition in your area. Again, email Matthew at TPOPP, and he can let you know who in your area is already involved in the project.
And just to reiterate, we will be posting the recording of this webinar on our YouTube channel. You can find us at Practical Bioethics on YouTube. There's already a TPOPP playlist that has a bunch of other content like this, so if you have other interests related to the subject, you might be able to find some stuff there. And just keep an eye out for this posting as well.
Awesome.
Emily, thank you for getting this on our agenda. Appreciate it very much.
Thanks very much.
We appreciate you. Thanks.
All right. Bye.
Bye.
Bye.